Hello, y'all. It's me, Miss McMillan, your friendly neighborhood lecturer. We're going to pick up where we left off yesterday, talking about sexual orientation rights and how those exist under the implied rights from the Ninth Amendment. So, if you click on this link right here, it'll take you to a news story that's connected to the case Lawrence v. Texas. In Lawrence v. Texas, they finally struck down sodomy laws. So again, just like with Griswold versus Connecticut, the idea of the government doesn't belong in my bedroom. And what this case is going to talk about is how they went kind of backwards in time and erased convictions of people who had been convicted under sodomy laws. So it's a really cool NPR story that you can listen to if you click on that link. At least I really hope it takes you to the correct link. It worked when I tried it, but one never knows with technology. Again, privacy, as we talked about. And then in terms of expanding rights, which we'll talk more about this when we talk about civil rights, but same-sex marriage was legalized in Obergefell v. Hodges in 2015. There's an off chance Obergefell might be coming to school to speak to us, so that would be really awesome, but I haven't heard any more about it lately. I will keep you updated once I'm updated. The way that same-sex marriage was legalized was through the Equal Protection Clause of the 14th Amendment. So they're not really talking about privacy, talking about equal protection of rights under the law. So using that clause of the 14th Amendment. It's a big amendment. You really got to know this one, know all those clauses. It will help you. All right, moving on. Rights of criminal suspects or those who've been accused of a crime. So this is the 4th through 8th Amendments. The 7th, not so much, really deals more with civil cases, but sometimes you can think of civil cases kind of like criminal cases, but there's no jail sentence attached, just fines usually. So the 4th Amendment, of course, everybody I think is familiar with. So that's freedom from unreasonable search and seizure. The idea that a warrant is needed. The warrant has to specify the place that's to be searched and what is to be searched for. So if they come in and they say they have a warrant to search your living room, they can't go into any other part of your house. Homes enjoy high degrees of protection under the 4th Amendment. So homes are really considered to be private, valued by the Founding Fathers as a place of privacy that the government was not supposed to intrude upon. So even things like the case that your book talks about with the drug sniffing dogs, they're not allowed to come up on your property and use a drug sniffing dog. That's considered to be highly invasive of privacy. Now they've determined that other places do not need to have such high protection, don't enjoy such high protection. So that's why when I come back from Bolivia and land in Miami, that they have all of us walk down one side of the hallway in a single file line and the drug dog's there to sniff and make sure nobody's trying to sneak drugs back in from South America. True story. Search warrants are granted by judges. So you have to present evidence to a judge and they sign off on the warrant that says, yes, you have enough evidence to proceed, or no, you're grasping at straws here. You really are just going to be harassing this citizen. So speaking of harassment, you guys might be familiar with stop and frisk programs so that police could just randomly and did randomly stop people on the street and frisk them, and then if they found drugs or something, then they could take them into the police station and arrest them. We know that stop and frisk unfairly targeted minorities, and so it actually was ruled unconstitutional. So no longer can you just stop and frisk people in New York City, even though President Trump advocated bringing that back. Stop and frisk, well, not stop and frisk, but traffic stops where then drugs are found and things like that are pretty controversial because the person being stopped, even though they could say like, I have the constitutional right to refuse a search, might then be arrested for the minor traffic violation. And that's been upheld in court, that even though traffic violations are not punishable, minor traffic violations are not punishable by jail time, usually only by fines, for whatever reason the courts have upheld that local police can toss you in jail for that minor traffic infraction. All right, technology is making the 4th Amendment protections kind of tricky. because there's this ability to surveil people digitally that people have kind of allowed with wanting access to free programs. So you give up privacy when you sign up for Facebook because you allow Facebook to advertise to you. And if Facebook didn't advertise to you, then it would be a service that you need to pay for. This is true of Instagram and Google products. So this becomes a trickier area of law. Um, if you guys remember the San Bernardino case when two people went into a workplace and murdered 14 people in an act of terrorism, one of the suspects, well, perpetrators, I should say, phones was found, and the FBI wanted Apple to help them break into it because it was an iPhone, and Apple was like, no, we don't do that. And the FBI was really upset, and Apple said, well, it's like a privacy thing. We can't build in these backdoors to phones because if we build them in, then any hacker can exploit that, and we don't want that. So it's not like just the good guys would have this backdoor key. The FBI eventually finds a way into the phone via some other program. I assume some hacker invented something. Anyway, they get into the phone, but it was a big battle between the government and Apple. And then, of course, the case a lot of you reported on this past summer, Carpenter versus the U.S., where it was stated that you need a warrant if you're going to try to track someone through their cell phone pings, basically when their phone pings a tower and gives their location, that you have to have a warrant to look at those records. Otherwise, it's considered invasive. So, interestingly enough, that was a very close decision. It was 5-4, but it did come down on the side of privacy rights. Again, with the Fourth Amendment, as with most of the other amendments we've looked at, there's always the need to balance the freedom of citizens versus the safety of society. So you need to think about, what kind of society it is that you want to live in. Is it, and it's kind of illustrated here by this cartoon, right? That you give up a lot of your liberty when you go to the airport and you fly in a plane. It's a pretty invasive procedure that you have to go through, but people have determined, well, I will give up some liberty to gain a measure of safety, kind of the idea that my plane won't blow up when I fly on it. This is now true of concert venues after those have proven to be places of attack for terrorists. And now you have to pass through metal detectors, have your bags searched. Rules have changed at OSU at the stadium. So I've gone to games a number of years in a row, and over time you've been allowed to bring in less and less and less. And again, this all comes down to, well, we want to keep you safe. So you have to decide, is it worth it? Is it worth it to give up, more of my freedom in order to enjoy more safety? And people come down all across the spectrum on this issue. So government's always trying to balance that, and I should say government and the people, because ultimately government is answerable to us, and the government will always want more security, but people may push back against that. After 9/11, of course, we very much came down on the side more of safety, right? So we have the government collecting massive amounts of data about citizens in the attempt to prevent another terrorist act. The Patriot and USA Freedom Acts give great latitude to the government. You had practices of extraordinary rendition where people were shipped out to countries where human rights laws were weak, where human rights were not as protected, so that they could engage in what's called enhanced interrogation techniques, which many people would just say is torture, and question people using torture to try and get information about where the next terrorist attack was going to be. Eventually, these practices are limited by the courts, by the turning of public opinion, and of course, the fact that the NSA was gathering all this data about citizens was revealed by Edward Snowden, after which the Obama administration curtailed that program. So it is citizens kind of keeping an eye on the government, the press keeping an eye on the government, that ended a lot of those practices. Those of you who are Law and Order fans will probably know about the exclusionary rule. So this comes out of the Fourth Amendment and was incorporated to the states in Mapp versus Ohio in 1961. So yay, go Ohio. The exclusionary rule is that if you get evidence in violation of the Fourth Amendment, so if police gather evidence, in violation of the Fourth Amendment, it can be excluded at trial, hence the exclusionary rule. You can't use ill-gotten evidence, basically. In Mapp versus Ohio, this is a case where Police were looking for a bombing suspect, and they entered a Dalry Mapp's house, showing her a warrant, though it's unclear if it actually was a warrant, and went through her house searching for this person. Didn't find the person, but discovered a trunk full of porn underneath her bed, I think, or maybe in a room somewhere, and they arrested her on charges of possession of obscenity, because at the time porn was illegal, and she sues and says, you can't do this because that's not what you were searching for when you came to my home, and she wins. The court sides with her. So there you go. There is something called the good faith exception. So if you didn't realize that there was a problem with the warrant and you got the evidence, you weren't trying to violate anybody's rights, a lot of times that evidence can still be used. You can go into somebody's house if you hear evidence of a crime being committed. You're allowed to enter. So if the kind of a crime is in progress, you can enter and obtain anything that way. If you see evidence of a crime lying around in plain sight when you enter looking for something else, you're allowed to gather that and use that as evidence of a crime in progress. This happened, a story my father-in-law, who was a cop for a long time, tells. And there's this guy who was scheming pharmacies, basically. He had this elaborate scheme and was getting all these drugs from pharmacies and selling them and making a killing, and they couldn't catch him because he had this, I don't remember what the exact details were, but he was really good at it. He ends up getting caught because the police come to his door on something unrelated. He thinks it's one of his customers, and he answers the door, I think with a crack pipe or something. So they are able to enter, and then they discover all these mass amounts of pills and things that he had in the place. So, I guess he was brilliant for a while and then not so brilliant. Okay, the Fifth Amendment. Again, Fifth Amendment protecting you from the excesses of the government. So right to remain silent. The government cannot coerce you or force you into a confession of a crime. And if you're being questioned about something and you know that your answering this would lead to the revelation of another crime or the appearance that you may have committed a crime, you frequently will invoke your Fifth Amendment rights. The government has to prove your guilt. So the burden of proof rests with the state and not with the defendant, which is maybe harder to remember in the age of the internet and sort of almost mob trials in a sense, right? That people are convicted in the court of public opinion but may not actually be convicted in the court of law. A couple of the rights that are in the Fifth Amendment are no double jeopardy, which I think we talked about before, that you have the right to have a fair trial and a jury of your peers. Miranda warnings come from the Fifth Amendment. So we get those from the case Miranda versus Arizona from 1966. Basically, this guy was like super interrogated by the police for 2 hours, and he's like, okay, I did it. And he'd never been told that he had the right to remain silent. So he sues, and we get the Miranda rights where you have to be told that you can be silent and that you have the right to a lawyer. There's one exception to this, and that is the imminent danger exception. So if and this was witnessed in the case of the Boston Marathon bombing, the one suspect survived an encounter with the police and was questioned without, I believe, without the presence of counsel, because they didn't know if there was another bomber, like were there more attacks happening. So they used the imminent danger exception for that. In terms of fair trial, that comes out of the idea of due process. So in the Fifth Amendment, you're guaranteed the right to a grand jury. The grand jury is made up of a lot more people than what's called a petit jury, or you guys may be familiar with the 12 jurors, right? And not all states use 12 jurors, but 12 is kind of the standard number. Of course, the play 12 Angry Men, right? I think that most of us have read it at some point in an English class in some grade. Interestingly enough, the crime rate has radically decreased since the 1990s, but the public still sort of sees crime as this huge problem, even though crime rates are really historically low right now. All right, the Eighth Amendment. So there's been evolution on this over time, right? In the beginning of our country, there were a lot of ways that the death penalty could be used and was not held to violate cruel and unusual punishment. The Supreme Court actually put a moratorium on the death penalty for a while in the 1970s, and then it was lifted and brought back because there are a lot of problems with the death penalty. One being that there's clear racial bias in terms of who gets sentenced to death. With people of color being sentenced to death at a much higher rate than whites. Over time, the Supreme Court has said, you know what, executing minors or those who have mental handicaps is not permissible. That is cruel and unusual punishment. So we see the court evolving. Some states, are already saying, we're not going to do the death penalty. They outlawed in their states already, but it is legal at the federal level, and some states still do use capital punishment. Ohio is included in that. So, are our civil liberties under siege? Right? Some would say yes. Some would say no. If you look at the Patriot Act, I would think that you could very strongly argue that yes, civil liberties are being eroded because of the war on terror. War on terror is such a big thing. We talk about foreign policy a little bit later, and domestic policy too. So the question comes down to, in the end, sort of Congress and the courts. What is Congress's role to safeguard individual liberty, and what is the court's role? And should one be taking a sort of stronger role than the other, because the executive's tendency is going to be towards erosion of civil liberties in the name of safety? So what do you think? Consider it. All right. Thanks for listening. This is your friendly neighborhood lecturer signing off.